Let's call this meeting of the Eugene Planning Commission to order on, this is November 5th. First item on our agenda is public comment. And we have nobody seeking to talk to us this morning, so we'll go on to agenda item 2, the Good Pasture Island PUD Off-Site Transportation Improvements Remand Deliberation, City File WG 10-3, LUBA number 2011-049. It's decision time for us, folks. We've received an awful lot of information since the public hearing. And to help keep us on track, I've asked Steve to keep the tasks on the board. They've disappeared on us. This is a remand, very focused, narrow questions that we need to deliberate on and make a determination on. So I've asked Steve to keep these up throughout our discussions, and as long as we stay on task with those, keep everything directed at those issues up there, I think we'll be able to, by the end of today's meeting, ensure that staff has enough direction from us so that they can prepare findings and a final order for our consideration the next time we get together on November 15th. Steve?
Yeah, I have some concerns that there seems like there should be a third.
Well, let's after the staff, let's get into some stuff, okay? A couple of things we need to clear. Commissioner Duncan is back with us. He was down on the Colorado River checking out the flow of that river, I suppose.
Yeah, it flowed really nice.
Yeah, Rick, we need for the record for you to verify that you have received and reviewed the record since you missed the public hearing.
I've reviewed all the information, and I viewed the webcast on computer late last week, so.
And feel yourself ready to participate?
I'm ready to go.
Very good. And Emily, City Council for us, want to tell us about the evidence that was withdrawn and how we should not let it affect our thinking?
Yeah, actually, I want to back up excuse me, to an issue similar to Duncan's. We actually have two new commissioners who were not here when the matter originally came before you last April of 2011, and I'd like to get on the record their statements as well, that they've had an opportunity to review all of the record that came before them in addition to everything that they have received having been on the commission.
Commissioner Jaworski, have you?
I've reviewed everything, all the CDs, and participated in the public hearing.
Feel confident that you can participate in this matter?
Confident? I don't know how you define it. Yes.
Very good. Commissioner Baker, the same?
Yeah, I've reviewed the CDs and
The volumes?
the volumes.
Okay.
Unfortunately, I have.
That's good. So with respect to the evidentiary issue, as you know, this matter came before another public hearing where you accepted new evidence on limited issues, and you set out a timeline after the hearing to keep the record open. And during the time when the record was left open only for argument and no new evidence, October 17th, staff received and sent you a link to two documents from Willamette Oaks, from Mike Farthing's office. One was a letter from Mr. Farthing, one was a letter from Mr. Lindsay, their expert. On October 24th, we emailed you to tell you that those two letters had been withdrawn from the record. They were withdrawn by Mr. Farthing in response to concerns raised by Mr. Robinson that they contained new evidence. And to nullify the issue, Mr. Farthing has simply withdrawn them. At that time, we took them off the Dropbox, and you could not get them, but you may have had the opportunity to look at them or download them. I advised you to ignore them if you hadn't seen them. You wouldn't be able to get to them now. To destroy the copies that you had, and to the extent you had looked at them, don't consider anything you read that was new evidence as far as your deliberations. Because they were withdrawn, and I know the staff report says because they're withdrawn, you don't need to officially reject them. You're going to have a cleaner record if you do, and so I've actually decided that I would like you to address that by a motion to officially reject the original October 16th letter from Mr. Farthing and the letter from Mr. Lambie also dated October 16th.
Would you make that motion, please?
Sure. I move that we officially reject the October 16th letter from
Mr. Farthing,
Farthing and also the letter from Mr. Lambie.
Is there a second?
Second.
It's seconded. Any need for discussion? Mr. Duncan?
Just since I received notification before I even looked at the document, I never even looked at it. Should I still be involved in the
Yeah.
vote? Okay.
Any other questions or statements? All in favor of the motion, say aye.
Aye.
Opposed, say no. Have
that'll be reflected in your final decision. I do want to clarify, though, that Mr. Farthing submitted another letter dated October 16th where he had redacted the information that Mr. Robinson had found objectionable. So you do have one letter in your record dated October 16th from Mr. Farthing, and it is a clean letter that you can look at, and staff have worked hard to make sure that's the only one in front of you. But if you have any questions at all, we're here to...
Any questions from anybody?
Is that clear? Okay. I guess the only other thing I would add is it's certainly fair game to talk about whether we have successfully captured the issues on appeal. But to be clear, as I said at the hearing, this process began with a hearings official decision where there was no limit on the issues that folks could raise. It was appealed to the Planning Commission last April 2011, where 12 issues were raised. 12 issues were considered. You made a decision on those issues. It was appealed to LUBA, where 6 issues then were raised. This is a winnowing process where we get down to fewer and fewer issues. 6 issues were raised at LUBA. LUBA found 2 of them were still alive after they were done. Court of Appeals looked at it, agreed that 2 of them were still alive. 2 of them are in front of you now. You need to address the issues that LUBA has remanded to you, and we can talk about whether we've successfully captured those here if there's concerns about that. But you can't address anything new or anything other than those 2. So for that reason, you may hear from us at certain points that we're not sure how your discussion is relating to one of the issues, and try to keep you on task that way. The other thing that you may hear from us, because the record is closed now, as you ask questions or ask for information, you'll hear staff often say, I don't think there's anything in the record on that. That's not to say we don't know the answer, but in fairness, we are not presenting you with any new evidence at this point either. So you may hear, we'll look in the record to see if there's anything about that, or there's nothing in the record about that, and you just have to live with that at this point.
Questions for Emily? Commissioner Baker?
Yes, Councilor Jerome, when I read through the LUBA decision, they sustained 3 of the assignments of error and partially sustained 1 of the assignment of error. But the way these have been reorganized is into 2 issues.
Well, the assignments of error are, and I'm not sure how you can break them down however you want. The substantive issues are captured in these 2 tasks. And we haven't heard either party argue that there's anything that LUBA remanded that we are not addressing in looking at these 2 tasks. We try to provide you with essentially questions for you to answer that relate to our criteria, not necessarily to the assignments of error as they were raised at LUBA. But if at any point you think that there's something that was raised in the LUBA appeal that we're not addressing, I appreciate your diligence in looking at that.
I just wanted to clarify that theoretically those 2 issues should be comprehensive and cover all these.
Everything that
was
was
sustained.
right.
Okay. Any other questions for Emily? Emily, would you also be just kind enough to let us know what happens on a remand, and once we come up with some final decision, where does it go from there?
Well, I can't say factually, but I believe that, well, you'll make a final decision, and there will be 21 days in which either party, only these 2 parties at this point, could appeal again to LUBA. And track record has it that we'll probably go there.
It does not automatically get sent back to?
No.
Okay.
No, I mean, if we can resolve the issues in a way that both parties agree is either correct or not worth appealing, we'll be done.
Okay,
Yeah.
thanks. Steve?
And one other question related to that, I assume that if it goes to LUBA and then those parties could then appeal to the Court of Appeals again?
Yes.
Okay. Just understand the process.
Yep.
Okay. Steve, staff presentation on both tasks before us, please.
Yes. Yes, as Emily said, there's two primary tasks that had clear guidance from LUBA, and I think where there was, under task one, it kind of incorporates really, depending on how you answer task one, there was other criteria that fell underneath that also, so that's part of their remand also. So the assignments of error are captured in both tasks 1 and 2. And so in the AIS, staff took the approach that the Planning Commission was right the first time around, and that with supplemental information that the LUBA remand can be answered in the affirmative. LUBA did provide pretty clear direction on each of these tasks we try to capture in this, and that was they disagreed with the Planning Commission's original, I guess, findings under task 1, that the Planning Commission said the river is not here, it's over there, half-mile away, and LUBA said we need more information, and you should, at the very minimum, look at the definitions in the statute that provide more relevant context, and we have there that that's the state's definition of the river and channel is where they guided the Planning Commission at a minimum to address those. So that is that's kind of the minimum, and then there was a lot of additional arguments that are also included in this packet of material that y'all have, and depending on the answer of where you go on the channel, some of the arguments could be used to supplement your findings, but staff really feels that concentrating on that definition is kind of the real crux of the issue.
Okay.
And then on task 2, that related to the open space designation and whether or not the Metro Plan policies and Willamette Willikinzie area plan goals apply to the project, and in kind of the same vein, LUBA said at that one that they said just because it's unzoned doesn't mean Metro Plan policies and Willikinzie area plan policies don't apply. There may be other reasons the goals and policies don't apply or not in the way Willamette Oaks suggests. So, kind of in the same vein, they were saying that they needed more from the Planning Commission in order to, I guess, answer in the affirmative. So I think looking at that, the way we laid it out in the AIS was to look more closely at the policies and goals and to determine if they apply, and then if they apply, if you agree with the applicant's findings that even if they apply, they have been met. So, and then given that stack recommendation on both tasks was that there wasn't enough compelling evidence to overturn the Planning Commission's initial findings, and that the additional information provided by the applicant can be used to support the past approval while following LUBA's direction on remand. And so that's a basic summary of where staff provided in the AIS, and if there's any questions.
Are there clarifying questions, not deliberation, but clarifying questions for Steve at this time? Commissioner Duncan?
Just a clarity, I think I heard you say that LUBA disagreed with our findings. I thought the way I read it, they didn't necessarily disagree, they just simply said, we need more from you. Not that they disagreed about our conclusion. Is that correct?
That's correct.
That was my reading of the remand. Okay.
Yes, they disagreed with, I guess, the level of findings needed to reach that conclusion, that they wanted more.
I just was
But
concerned
not
about the
with
phrase disagree. They didn't disagree, they just said, we need something more from you for clarity purposes.
Yes.
Okay.
Other
Yeah.
questions for
I will say that, one of the things that was pretty clear in your initial decision was the interpretation of the river, or the Willamette River, as being only the main channel. And I think that they would disagree with that because of this definition they asked you to consider, and which says it includes all channels. So they, the final decision, I think no matter what it says, we do need to change our determination that the Willamette River only includes the main channel. I think that'd be the only thing where I might say they disagree with something.
Any other questions for Steve? Okay. Rick?
One for Emily.
For Emily? Okay, that's okay.
Just from procedural standpoints, if we were to decide that our original decision was in error, I'm not suggesting we are, but if that was to occur, does that then open up that entire decision that we did before?
No, it opens it up wider, though. There were specific, when excuse me, when Willamette Oaks appealed to LUBA, they alleged that that determination was wrong, and then they went further and said, and so the city's findings that relied on that determination under this policy, this criterion, and that criterion are also wrong. And they're specifically listed under 1B.
Right.
So if, in fact, you decide that the Dedrick Slough and the Delta Ponds are a channel of the Willamette River, then you will need to re-look at your analysis, redo your analysis under those particular provisions, but no others.
Okay, thanks.
Okay? John?
Are our questions restricted of staff only to clarification or the document that they provided as a staff report?
I'll go ahead and ask that, too.
Okay. On page 4, there's an item that indicates as some of the supporting evidence that the state typically holds title to all beds of rivers, and the area in question is owned by the city of Eugene. I guess my question, because I couldn't find it anywhere, the state therefore does not hold title to any channels, or do they elsewhere?
Oh, so the state typically holds the title to channels.
They do. Okay, that was not stated. I just wanted to make sure that they typically do. Thank you.
Anyone else? Okay, well, to the extent that an analogy might help guide us through this, let me offer that this, to me, was similar like a football replay. We've got a call on the field. We have a hearings official affirmed by the Planning Commission that certain aspects of the Willamette Greenway Law, the Metro Area Plan, and the Willikins Area Plan do not apply to this specific land use decision. LUBA, however, has tossed it up to the replay booth for a second look. And the second look now is up to us to either clarify that either the call on the field stands as it is, or is there enough for us to overturn the call on the field? And if there is, we need to determine the evidence that supports that. So let's take these things one at a time, task 1 and task 2 separately, and just to see how close together we are or how far apart we are, I'd like to ask the members of the commission 3 questions. And this is a poll. This is not even a straw vote, so don't be concerned that we're taking some action, but just to see where we are, let me ask you on that determination of channel. If you are inclined to determine that water either does not flow at ordinary low water in Dedrick Slough, that it does flow at ordinary low water in Dedrick Slough, or if you're still undecided or need more information at this time. So let me pose those 3 questions. See a show of hands just to see where we are on this, okay? So show of hands for people who are leaning towards determining that water does not flow at ordinary low water in Dedrick Slough. Okay. Show of hands people that are leaning towards determining that water does flow at ordinary low water. Okay? And so I would take it then nobody's confused. All right. Let's begin then by giving reasons for where we are each at in this and see how we can work through this. Okay? And I'm willing to begin just to give us a point of departure. And I wrote this down, so bear with me so that I don't cross up my own thinking. So the question is flow at ordinary low water, to me, the arguments came down to being dependent on either a surface water connection or can that flow be established in a groundwater connection. Good Pasture contends that surface connection is what counts and that ordinary low water there isn't a connection and therefore there isn't flow and therefore it isn't, Dedrick Slough isn't a channel. Willamette Oaks, on the other hand, contends that a groundwater connection counts and that there is a groundwater connection and therefore there is flow in Dedrick Slough making it a channel. We've heard expert opinions from surveyors and hydrogeologists and geologists, and they all disagree as to whether there is a groundwater connection to the main channel of the Willamette. From my perspective, however, even if there is a groundwater connection, I guess I have to wonder if that's legally relevant in this case, based on the evidence that we've heard. And first off, ORS 274.005 defines line of ordinary water as, and I quote, the line on the bank or shore to which the low water normally recedes annually in a season, unquote. And in terms of evidence, there's the ordinary low water lines have been established by, at that time, the Division of State Lands in 1975. The lines have been established on the main channel of the Willamette only, not on Dedrick Slough. They haven't been extended to Dedrick Slough. And then this was significant to me too. The City Ordinance 2592 opts to use the top of bank rather than the ordinary low water line in adopting the greenway boundary in the vicinity of Dedrick Slough. I found that whole discussion in the maps and the information by Pogue Engineering to be relevant in that regard. And then ORS 537.515, this was real key, defines groundwater as, quote, any water except capillary moisture beneath the land surface or beneath the bed of any stream, lake, reservoir, or other body of surface water, unquote. And that to me became real important because there's a lot of discussion between groundwater law and how water pertains in the Willamette Greenway law and surface water law and navigability. And from my own experiences, I know there's a lot of confusion in that regard. So my position going into this is, despite that whatever scientific or geologic connection there may in fact be between the groundwater and the surface water in Dedrick Slough, for purposes of ORS 390, the Willamette Greenway law, it appears to me that the focus needs to be strictly on surface connections, not on the groundwater connections. And then referring to the ordinary low water line that's established on the main channel of the Willamette, the AKS survey for Good Pasture demonstrated that there is no connection at the upstream end during ordinary low water flows. In regard to the downstream connection, I found it interesting the Kellogg Lake Luba decision. Seems to me that there's some relevance there, Emily, in that the Dedrick Slough can be defined as a tributary rather than as a channel of the Willamette River, and therefore, and I'm quoting this from something, is outside of the setback measured from the water line on the main channel. It's simply too far from the ordinary low water line that is established by the Division of State Lands on the main channel. And so for me, the bottom line is, for purposes of the Greenway law, water in Dedrick Slough does not flow at ordinary low water, and therefore Dedrick Slough would not be a channel, and this land use action would not be required to abide by the Greenway laws in terms of the setback. You want to put your 2 cents worth in?
Sure. I looked back at the, on the Luba decision, and on page 13, it started by saying there was no definition of the Willamette River in Goal 15, but it is defined in ORS 390.310 to 390.368, and that includes portions of the Willamette River, including all channels. And then they further define channel in ORS 390.310.1 as any channel that flows water at ordinary low water. And for me, that seemed to be the relevant context that Luba was looking for. On page 14, lines 1 through 3 of the Luba decision, it also stated that there is some evidence in the record indicating that the water in the Dedrick Slough flows throughout the year, but that evidence does not identify whether the water flows at ordinary low water. And for me, that was really the tipping point, that it may flow at times during the year at higher water or that sort of thing, but that the definition really narrows for channel to any channel that flows water at ordinary low water. And in looking at the evidence that we have, I don't see where the surface water flows at ordinary low water. And I, again, I think echo the concern about mixing the groundwater and the surface water. I think that's really not what I get out of the definitions and the way that it's presented throughout the ORS that I looked at.
Rick?
Well, I think you summarized my feelings quite well. I had a very difficult time, in reality, mixing groundwater with surface water. I think that the statutes are clear, that there's a discussion about low water marks. There's also a discussion in there about surface water and also the low water mark in the channels or river, whatever we want to describe as the slough or not. And in the work that I read with regard to the engineers' discussion, there was actually some comments where there were berms and dikes and so on that actually exceeded the low water mark, which means that the water, in my mind, would have to become groundwater under the definition under ORS versus surface water flow. And given that, I felt that what we had was not a channel because it didn't meet the criterions that set forth for ORS within the Greenway laws. So I'm with you on the comments you made for the rest of it without citing all the rest of the ORSs and so on.
John?
I found this issue quite difficult, and the reason was I thought that the definition so defined under 390.310.1 was very vague and didn't relate to other uses of the word in many places throughout the, 1,000 or so pages of record. They actually refer to the word surface water flow and not just the word water flow. I was also confused because when you try to say groundwater, you can get the definition of it, but there's also groundwater that has a discharge area where it comes to the surface. So what is it then? Either a spring or what have you. So that was very difficult for me, plus the testimony between the two experts in that particular area. So what I came down to was to look through the records, and on page 893, 894, the various studies that were done there. Under hydrology, it states the delta ponds currently have no regular surface inflow from the Willamette River. And then on 894, it states during the summer months, this area has direct connection to the Willamette River versus Dedrick Slough, which drains to the north. Dedrick Slough is a remnant side channel of the Willamette River. So from those things, it was saying to me that here's a party to the definitions and the study area that was done prior to and has no specific interest in the outcome of this particular issue. On that, in looking at that is why I now lean toward the fact that based on what I'm reading here, that it is not a channel.
And Steve, let me ask Jeff for his viewpoint, and we'll jump to yours.
Well, I think it's been stated pretty well, and some of the questions that do exist have been laid out there pretty well by John and Rick and Bill and yourself, Randy. I guess for me, it kind of goes back to the thing that I did was try to understand or come to an understanding of what I believe the intent of the definition is. And to me, everything, all the wording, all the structure, everything around it seems to focus on and refer to surface water flow. They refer to low water, high water. Those are all surface terminologies. There is groundwater flow, certainly, but measuring of it is not an easily knowable thing. You can say, yeah, it exists because of the things we know about hydrology, but to know if it has what its seasonal range is, I don't know that we know that. But I just go back to the intent of the law, where to me it's clear that it's referring to surface water flow, and therefore, by definition, we don't have a channel.
Steve, how do you view it differently?
I viewed it differently. Again, I think the definitions in the state law are not clear, and they define groundwater in a completely different place, and they never reference it here. They don't mention the word surface water here. And to me, what was telling was there is a connection at low water level on the upstream end, on the outflow, and there is data provided that there indicates there is a substantial flow at the upstream end, and which indicates that there's got to be some water flowing in, and actually based upon the elevations of all of that were provided there that were not counteracted, there is a continuous flow from the southern end to the northern end of that area. And it turns out that there isn't a surface connection at the very top, but there's clearly a flow from, a few feet from where there would be a connection, all the way down to the northern end, based upon the elevations and the elevation that's at least provided in the testimony, and it was not refuted by Good Pasture Island. Any of their testimony indicates that flow occurs at low water level because of the elevations of those areas. So you have flow in, then the only question is the water that's flowing, you have some water flowing into the Willamette River as some sort of, whatever, you don't want to call it channel, but at the northern end. So where is that water coming from? If it's, if it's coming from percolation and from the side of the Willamette River through this, essentially loose gravel, then to me, if there weren't a connection at the northern end, I wouldn't have any question about it. But we have a fairly well-established connection at the northern end that shows the flow, and here's this water. Well, where is it flowing from? And the only reasonable assumption that I could make, given the flows, is that it's coming from the river. I should preface it that I worked for the state for 15 years, and I coordinated rivers data for the state for 15 years. So I worked with 15 different agencies on rivers, so I have some innate background in this area that others might not have. So that's the way I interpret it. If there wasn't this connection at the northern end, then you could say that these are isolated ponds, and however they fill up, that's the way it is. But there's a connection at the northern end. There's a continuous slope all the way along the channel toward the north. That's the normal thing you would expect of a channel or of some device that's carrying water. How it gets in there, well, we could be question about it. And reading through the Bureau of all of the technical reports there, it seems to indicate that they even put a weir in there to block the flow. So, obviously they knew that there was a flow because they actually put in a device to slow and limit it for flood control in some period of time. So, and also we know from historical data that was submitted that this was once the main channel of the river. anyone that's worked on rivers knows you dig down underneath the river and you find the river flowing beneath it. It's like the Upper Mackenzie, even where they drained it, where the Carmen Smith Dam drained the river. You can dig down in the channel that's drained.
That's probably verging on new evidence.
Yeah, anyway, but the point is, it's just, from my point of view, if there's flow coming out, it has to come from somewhere, and we have to determine where it's coming from.
And I appreciate that, and that was that downstream connection kind of was a missing piece for me until I read the Friends of Kellogg Lake, or whatever that case was, that established the point in there that's in the record is that Kellogg Lake, connected by, I think it's called Kellogg Creek, is some distance away from the main channel. And they determined in that case that the provisions of that Clackamas County Code did not pertain to Kellogg Lake because of the distance from the main channel. And that's, for me, what made the connection between where the ordinary low water line was established by DSL in the main channel, and then trying to translate that back into Dedrick Slough, which again, going back to the call on the field, both the hearings official reaffirmed by the Planning Commission saying Dedrick Slough is too far from the river. And those were the points that I connected in my mind in that regard.
Could I ask a question? So in that report, did it document where the flow was coming in to fill the Kellogg's Lake? In other words, was it coming from, adjacent hillsides at all, or?
I don't know. I don't believe it.
Because that would make a difference from my point of view. Obviously, if you know the sources, if the source is not clear where it's coming from, and you suspect that it's surrounding terrain because of the elevation changes, then you might have a different interpretation.
Any other questions, deliberations among the group here, among the Planning Commission members? John?
Yeah, I don't know if we're supposed to speak to something that's said or not.
Go ahead.
Okay. When I read the material on the flood...
Steve will kick you out of the room.
Okay. When I read the flood control thing, I read it to me, the understanding was that it was put in to control high water flows and regulate that. And I think in the document it also states that there was no flow at low water, which was kind of interesting. The second thing is that I also had trouble with the elevations, but since there was no evidence to show that the bank, however short it is, let's say it's 20 feet wide, 5 feet wide, that it had permeable soils so that one could say the actual water is coming through those and into the potential channel or no channel through the ponds. And it is difficult to prove where groundwater comes from. So that's what led me to say that there was inconclusive evidence to indicate flow. At the end of this, though, I don't know if we're allowed to make recommendations to the state on something they should do for a definition, but I have a few.
Yeah, I was ready
okay.
to fire this back to Luba.
Yeah, I have a few on that definition.
Okay.
We'll let Emily handle that.
Tell them what we think. Okay. Anything else, John? Other comments from the Planning Commission? Steve, Emily, you have other points in the staff notes. Is there anything you would like us to comment on that would help you draft findings, or have you heard enough from us?
Well, I think on page 4 there's also some additional information that the applicant, or points that they made, and so I guess in moving forward, if there was, I guess, any disagreement with anybody when you looked at those as to what the applicant said about them, they're kind of starting in the middle there. They kind of provided additional information about the history of the area and the ownership.
You're talking about page 6 of the AIS. Page
Oh, yes,
4.
I'm sorry. Correct. And then there was also just relying on evidence from the Delta Ponds Restoration Project about the high water mark, and so I guess in moving forward, if there's any disagreement about including those as kind of additional information as to why you reached the conclusion that it isn't a channel,
In other
I
words,
guess we'd like to hear that.
I think, yeah, we would intend on including those points in a draft final order unless there's objections specifically to the items that are summarized there.
Well, Bill has a motion that I think he's ready to put out on the table, so let's do that at this time and see where it lands, okay?
Go ahead.
Okay. In regards to Task 1, the Willamette River issue, I move that the Planning Commission considers the state's definition of Willamette River and channel at ORS 390.310 and relies on evidence provided by the applicant regarding flow at ordinary low water, as well as the history of the area to support the Planning Commission's original conclusion that the Delta Ponds DeBrick Slough are not a channel of the Willamette River.
Is there a second?
A second.
Rick has seconded. Okay, open the floor to discussion. Would that capture what you're looking for, Steve and Gabe? Okay. Rick?
You opening for questions on this?
Yes.
Okay. Did I hear correctly, because there was some definitions about, I thought it was important that we talk about some of the definitions, like there's also the groundwater flow and some of those other definitions to be sort of added in. I mean, they've been comments that we've all sort of alluded to. It seems to me it just strengthens the discussion of surface versus groundwater and how we felt there was a true difference between the two.
Did you capture those to the
I
extent?
mean, is that part of the motion, or I'm trying to get clarity on
Yeah, I think we're scheduled to have final findings and a final order on November 15th, and what I'm looking for is just to give staff direction here, and I'm hoping that they've captured our comments to the extent they feel it's useful and relevant to be incorporated towards.
We have them on the webcast.
Okay.
Okay, but I guess my clarity is that was fairly specific about certain issues, and I wanted to make sure that staff would be allowed to expand beyond that.
You feel comfortable with that?
Yes. With some of the other elements. I think that there were some other things I thought, there was a couple of comments about case law that I felt were important, and then actually in Mr. Robinson's letter of October 23rd, there is a pretty good summary, which this actually captures most of it, but there may be a couple other points that might want to be reviewed on page 13 and 14. And not that I want to capture his comments, but I want to make sure that we don't get this remanded back to us again because we missed something.
Let me ask on that point. Regardless of the decision that the commission might make in favor of Good Pasture or Willamette Oaks, in developing the findings, might you work with the appropriate attorney to make sure the case is LUBA-proofed?
Yeah, I mean, what I usually do is seek assistance where I can get it, and especially in these matters where I think that no matter what you do, you're probably going to get appealed. If it's a decision that Willamette Oaks likes, I would expect that we would rely heavily on Willamette Oaks to defend the decision, and likewise for Good Pasture. So I would actually like to make sure that we've either made the arguments they want to defend or specifically decided we don't agree with them and we don't want to include them in your decision.
And the motion gives you that latitude, Emily?
Yeah, I mean, the motion actually doesn't address your concern, but I don't think that it prohibits us from also including that, and that is always what we would do. First and foremost is to describe the good discussion that you had here, and then also include the bases that were talked about.
Rick, I think when we see the final findings, then we can react to those. How's that?
I just on this one, this is not the first time we've seen this issue, and it may not be the last, so the more we can fill our findings,
Okay. Yeah.
because I think the last time we did this, we thought we had them full, and apparently we didn't, so
We came close.
Yeah.
Yeah.
On remand, we're learning. Pretty soon we'll write volumes ourselves.
And I think Luba just wanted a definition of flow.
They could have saved a lot of time if they'd have done that, yeah. Okay, I'm good.
I'm fine with providing support with the attorneys, but what I didn't like was where you provide a smorgasbord where you say, if we do that, either we agree with this, then we have this. I don't like that as an approach that we should take. In other words, we should either decide it's a flow and just, right, but not have all kinds of other stuff in there that says, well, if it's not a flow, then we justify it some other way. In other words...
Favorite thing to do.
Pardon?
Actually, we almost always write our decisions that way because at least my job for the city is whatever you decide, I want to make it stick once you decide it. And so it's important that those even if arguments, that you agree with them. But as long as you do agree with them, they make your decision a lot stronger.
Well, then I think we need to take a look at those even if, because if it's such a smorgasbord that some of us don't agree with some of those.
Yeah.
And we will, Steve, but...
I don't think there is one on this issue. I think there might be on the next one.
Okay, and again, we'll have in advance, we'll be able to review the findings and get into the nitty-gritty.
Yeah.
Yes, and I think in general, what I heard was that there was agreement that there is not a surface connection on the southern end, and that kind of even if there was a connection, or not knowing where that's coming from, that the Planning Commission doesn't feel like that means there's flow in the channel based on that. I mean, in general, and then we can expound from there. But
Bill?
And I think, too, what maybe helps me is in the AIS, at the bottom of page 5 and the top of page 6, items 1 and 2, that information there, I think, really captures and summarizes some of the additional information that really helps that along. And that was, I guess, my intent that would get included, too. So.
Okay. Any other comments? John?
When do we make a comment about this definition, that we should send something to them?
I'm going to suggest that we hold that at the end. Let's get the action on that's before us out of the way. I think that's probably an interesting idea, but not necessarily relevant to what we're being asked to decide. Okay. So there's a question on the floor. A motion on the floor. All in favor of the motion, say aye. Aye. Opposed, no.
No.
Okay. Motion carries 5-1. So on to question 2. Can somebody hit the projector? Task 2 gives us a couple of different options here, and again, let me just try to get a poll on this as simply as I can. And the questions I would ask is, first, and we'll do this together, we've got 2 policies here, policy H1 in the Metro Plan, and then a certain provision in the Willa-Kinsey Area Plan. Let me ask the general question like this. Are people leaning towards considering that neither of these policies are mandatory in this land use action? The second question would be, are you leaning towards the fact that they are mandatory? And then the third question would be somewhat undecided. And I know there's a sub-question in that, but let's try that. So the first question is, show of hands, folks who are leaning towards determining that policy H1 and the policy in the WAP are not mandatory in this land use action. Can I see a show of hands? It's not a question, just a show of hands at this time. So we've got, okay, 5. So rather than me asking any further, Steve, what is your question?
My question was, there's a lot of information in the record about that an exception would be required, and it would just require some additional work to get that exception. So that's what my question was regarding.
Specifically what?
Well, in other words, you could do those transportation improvements in these zones based upon these plans, but there's an exception that would be required to be filed and approved.
I can answer that.
Yeah, Steve.
Yes, and so that's directly related to the actually task 1, is if it was determined that the improvements are in the channel, then it would require the Planning Commission to go back to policy D11 and further explore that, whether it requires an exception or not. But based on the direction they've taken so far, that because it's not in the channel, then policy D11 would be addressed the way it was initially addressed by saying it's a goal exception isn't required because the improvements aren't in the channel. So
That includes, as I recall, that included the greenway as well, D11.
oh, okay.
And it's in the greenway, isn't it?
So it is in the greenway.
So it didn't matter that it was in the channel, it's just that it was in the greenway, so you still have D11.
Yeah, in the goal exceptions, it is difficult because there's separate terms, but there's actually it relies on or it's required if it's within a 35-foot greenway setback, they call it, which is measured from top of bank. So by saying there's not a channel, in essence, that's saying there's no top of bank and that the exception isn't required. I don't know if that.
There's two provisions that we're talking about. There's the greenway itself, that it's in the greenway boundaries, and then there's within the greenway setback. If it's in the setback, then this issue with the exception comes into play. But because you've determined that it's not in the channel, there isn't even any relevant setback nearby. So the exception is no longer applicable in this case. Does that help?
And so an exception wouldn't be required if it was the other attributes of that policy about building in the greenway?
Right. There's no question that it's within the greenway boundaries, and that doesn't in itself require any exception. And that's all we have at this point based on the direction you've given us.
Okay, Steve. Okay, so again, you had the opposite view on this, so let me just begin with my position why I'm leaning this way. And most recently, when we were talking about Envision Eugene, I talked about hoping that as we review the policies there, we somehow make a distinction between those policies that are applicable on kind of a city policy basis versus those which are specific to land use items. The Planning Commission has stumbled over those for the years that I've been on the Planning Commission. And to me, H1 and the WAP policies at number 6, as I recall, are those broad guidelines to the city as to what to develop in terms of parks protection and addressing it, so forth. So that's what puts these two policies out of the mandatory requirement from my perspective. On the other hand, just following up on Emily's concern, if LUBA should disagree and say, yeah, they are mandatory, I would be comfortable including well, here is the justification for that has been prepared. So that's where I'm at with it.
And I would agree with that. I think what helps me in this is the difference in terms, specifically the should rather than shall, because I think, I know in my business, if I'm directing a contractor to do something and I want him absolutely to do that, it's shall. The contractor shall do this. But if I say the contractor should do this, then there's a little more wiggle room, a little more room for interpretation, that sort of thing. And so I think for me that's a critical piece.
Just to comment on that, I think actually the way LUBA has been looking at these, for years and years we've been trying to impose policies like this on developers, and it's come back to us that it's not so much the should or the shall, it's the to whom it is directed. So they have looked at policies like this, or policies that are arguably like this, and said that they are directives, but they're directives to the city to do certain amounts of planning, and not to developers who are coming and proposing specific development proposals. So, and that seems to be the argument that we're seeing Good Pasture make as well, that they believe that LUBA would look at these and find that they are directives to the city and not to the private developer.
Yeah, I was just using that as an illustration from my business, not meaning, I was understanding it was for the city, not for a developer.
Okay.
Rick?
Yeah, I agree. I mean, when I read H1, I have always thought that was a direction for the city. Almost it should say the city shall versus we should. But yeah, I agree wholeheartedly that I've always thought that H1 really was more of aspirational for direction to what the city should do, not to what a particular project has to accomplish.
John?
On this particular issue?
Yeah.
I'm listening. I was still one of the undecideds, if you remember.
Oh, I'm sorry, I thought you raised your hand that you were leaning towards, okay, that's fine. Okay, Jeff?
Nothing to add. I think it's been covered.
Okay, then Steve?
Yeah, again, I think in this issue, I'm thinking back to previous decisions where we take the Metro Plan map and we make interpretations by it, based on it. It turns out we've made those decisions for the most part in zoned areas, but we take the map and we use it to apply to individual projects. And I can think of recent projects, one that I abstained from recently, where we essentially did that and made a land use change based upon the map and some wording in a local plan. So it seems to me you can't. I mean, either we take it here and we take it here, or we don't take it here and we don't take it here. In other words, we have to have some consistency in the way we handle these. So if in one case we use the Metro Plan diagram and we use the local neighborhood plan to make a land use decision that's specific to a project, it's not related to planning, then we have to follow that model in other deliberations, which would be what I consider this one. Now, it turns out this happens to be unzoned land, but we have some other examples of unzoned land, that we're considering for Envision Eugene, for example. That's park land, and we would assume that if we, that those are sort of more than aspirational. We're going to be making decisions based upon those. So that's my concern. We have to be consistent.
Emily and then Jeff?
You want to go ahead, Jeff?
I was just going to say, is this the opening to talk about the even-if argument that you were referring to earlier relating to task 2?
I'd just like to make a point of clarification to make sure that we capture your intent correctly. Should you go where it looks like you're going to go on this? Earlier in this process, staff had recommended you determine that the policies don't apply at all because it's unzoned transportation facilities. I think staff are backing away from that. Luba didn't like it. And we're saying, you know what, these are policies. It's clear policies apply, so we are going to look at them. And then the question becomes, do these policies have a directive that requires something of this applicant? So, and I think that's what you're discussing. Do these policies actually have a directive that requires something of the applicant? And so I think I'm hearing and not hearing anything different, that we're no longer looking at whether they apply at all. They do apply. The question is, what do they require of the developer? Is that what I'm hearing? Is that okay?
And that's something we kind of left out of the AIS, that step, I guess, of saying that it is green here, so we're going to look at the open space designation and all that, but then take the next step of, is it require anything different? So,
Steve?
So I think that's.
Let me hold off again.
Okay, Jeff, were you done with your thinking?
Yeah, for the moment.
Okay, John?
Yeah, not being an expert and having a chance to read the whole Metro Plan, are there policies in the Metro Plan that say shall rather than should?
There are policies that say the city shall. I mean, this H1 says develop a system of regional metropolitan recreational activity areas. It doesn't say who should, but you have to read it and say who can do that. Who are they talking to? There are policies that are written in every which way, written over time in various tenses and forms and directives and unclear and clear, and it is a constant struggle for this body.
30 years hindsight would be helpful today, John, but we didn't have it back.
Well, I just wanted to, what's written here on page 6 is I'm just trying to see if it's really, the applicant's interpretation, or is it always, and that's what I heard from you, it's not, is it always clear that should is aspirational and shall is mandatory? You're saying that sometimes should could be mandatory.
No, the
Oh,
courts
okay.
have been really quite clear on that.
Oh,
They
the
look
courts are
at
clear.
may and should versus shall in a very particular way. But what I was saying earlier is they seem to be more interested in looking at who the policy is directed to, who is the actor that they are talking to.
City or developer, okay.
Yeah, and, they try hard to make sense of these policies, which have been patched together over many years as well.
Steve?
Yeah, and my other, confusion is, the problem is, we're saying that we're making this a mandatory requirement of the developer, but it's being done on public land. In other words, it's not like I own this piece of property, I'm developing it, you're telling me I need to do this or that in order to comply with the development requirements or planning requirements. Now we're saying, we're doing this, but you're doing it actually on our land, on public land, and so it's like, if it were the other way around, one could say, well, but in this case, it's very confusing because of the nature of how this requirement was set up there, and it's like, well, who's really doing it? Well, the developer's paying for it, but the city is donating the land and is, whatever else they might do to allow it to happen, ultimately make a zone change that would allow this to be there or whatever in the future when it's zoned. So it's just not very clean.
Rick?
I mean, as part of a lot of development projects, the developer becomes responsible for improvements in the public right-of-way, be it put a new signal in, add crosswalks, whatever it is. So I've always taken that, in particular H1, because we're talking about it, is sort of a directive that encourages, I'm trying to find it again, encourages the city to really pay attention to these requirements when it comes to intensifying use within an area or a project where part of the public infrastructure is going to be affected, and it shouldn't be necessarily up to the public to pay for those. And I've always kind of thought part of the reasons why our right-of-ways are not zoned is somewhat to allow the latitude of different things to occur, that you couldn't say, well, you can't do that in a residential zoned area because you're adding a signal light in a residential area. But in fact, since it's unzoned, the city has the rights to do that, particularly under H1 in the Metro Plan, where it says the city needs to be the one doing that because it's not up to the private individual to make the determination what public improvements have to occur for the best part of the public. So from my standpoint, H1 is that directive for the city to work on behalf of us to really enhance our public right-of-ways for safe purposes and so on and so forth.
Any other comments? Bill's got, Steve?
Well, just one other thing about that, too. Just, again, that's the concern, because there's a balancing act. In other words, a decision was made based upon transportation needs, and we're actually deciding whether that decision actually fully considered the open space goals or policies as well. And again, that's the quandary from my point of view. There's a balance there.
I understand what you're saying. There is a balance between addressing parks and open space and this issue of increased traffic volume. And right from the very beginning, I mean, my initial gut reaction to this was if that right-of-way would not have been there already secured, and had this project been had to occur, the improvements made outside of the right-of-way, I can see we could be in a different kind of situation in our discussion. The fact that the right-of-way was secured, and I like the way Rick said it, that it's based for city future city actions regarding safety and improvements and so forth. The fact that it occurs within the right-of-way, even to me, goes to this question of intensification, which I don't know that we need to discuss, but that helped clarify for me the issue of balance. it conceivably could be that the city determined at some point in time, we might need to widen that bridge. The development at Good Pasture triggered that requirement. The city imposed on the developer, hey, go fix the bridge. It could just as easily have been, I suppose, on private land, to get to your earlier point. So,
I think that would have made it cleaner for me.
okay, well, but that's why we're here. So, any other questions or comments? Because I think Bill's got a motion he's ready to present.
Okay. In regards to Task 2, the Parks and Open Space issue, I move that the Planning Commission relies on the applicant's findings which analyze these policies and goals and describe how they are not applicable to the proposal, and that even if they are found to be applicable, the policies and goals are met by this application.
Is there a second to the motion? Discussion? Okay, all those in favor of the motion say aye. Aye. Opposed, no. Motion carries 5-1. And then just to wrap it up, you want to...
With these additional findings, I move that the Planning Commission adopt a final order affirming the approval of the applicant's Willamette Greenway permit for Good Pasture Island PUD off-site transportation improvements WG 10-3 and direct staff to prepare a final order for consideration and final action on November 15th, 2012.
Is there a second?
Second.
Seconded discussion. All in favor say aye. Aye. Opposed, no. That's unanimous. Well, we'll get to John's point here, but staff and members of the commission, thank you for doing your homework, and that went pretty quick. So you'll get things together for us to review prior to the 15th so we can...
Yes, we'll try to get to you as soon as we can, so you have time to review it prior to that.
Good.
I'm guessing it will be
Somewhere
getting
that
close
week
to there.
before.
So.
Now, John, do you want to talk about your suggestions and what might be appropriate? Oh, Rick?
30?
Yeah.
The 15th is
Yeah, I'm
a Wednesday, isn't it?
It's a
Thursday.
Yeah,
You know this on Thursday?
yeah, we are.
Monday's a holiday.
I didn't even have that down.
And it's in the Saw Room, too. It's different than...
That's the,
No,
No, that's the 9th. That's Friday's meeting.
yeah.
15th.
This could be in the Sloat Room, which is different from the Saul Room. Sloat Room is on the first floor, Saul is on the third floor.
The meeting on the 15th is in the slope.
Yeah, and we'll get this calendar all squared away here at the end of the meeting, but yeah, this one, for the attorneys, this is November 15th, which is a Thursday, and it'll either be here or in the Sloat Room, so,
But they gave us an extension.
that's the meeting we've told you for, and that's
Yeah.
where we're scheduled to go. And it would be at 11:30 as well.
11:30, yeah.
So we're just going to need to go through our findings and...
Correct.
Okay.
Final adoption, right?
Wasn't that because Monday's a holiday?
Yeah.
Some scheduling
Some
issues.
scheduling. I
The
think.
12th's a holiday?
The 11th.
Oh,
Monday.
Veterans Day.
It's Veterans
Yeah.
Day.
Okay. So, John, you want to talk about what you'd like to do? Create some state legislation, or...
No.
How about we just remand this to Luba?
John, if we're going to come up with this stuff, can we do that? Tell them to do their job.
Yeah, Emily?
Well, I don't think it's Luba.
Need a bad cop for that.
I just think there should be a comment. Otherwise, I think what we're doing here in our interpretation of this, I know how things are used as a precedent, and if there's any other similar cases.
Yeah.
And I'm saying that there were some issues that were so unclear that if they didn't have other, let's say, studies done of a specific area in other parts of the states which preceded the issue, and they use this as a basis, it's maybe not really applicable in my mind. So therefore, in clearing up this definition, which would be the state, I think, right, ORS 390.10.1, I just think they ought to indicate in there two things. One, if they're talking about flow, whether or not they meant flow or surface water flow, number one. And number two, when they say that there's surface flow in the channel, do they mean the entire channel or part of the channel?
Lots of
And I think those two issues would really, if clarified, have made this a lot easier for me.
How do we fix that, Steve and Emily?
You know.
Unfortunately, it
Well-
doesn't flow uphill.
You know, I mean, realistically, a good letter to your legislators. I mean, it's not something that anybody's going to be that eager to take up because it's probably come up, well, let's see, the Kellogg case and ours, you know, although it wasn't even an issue in that case. I don't know how much excitement you're going to get. I think a
I don't
more...
want excitement, I just want to redefine.
You want something done. Well, I think a more likely path towards getting clarity on it is to get an Oregon administrative rule that implements that provision, and so you need to look at asking DLCD, I guess, would administer that under Goal 15, to do a Goal 15 rule revision to define the term. That's a lot more likely to materialize.
And that likelihood's about this much.
Well, you know, I don't know. I mean, I know it takes us a long time too, but we do code updates and revisions now and then. And something like this, I would think would be fairly non-controversial and just...
It's really more a matter of that happens to be an area that they're looking to do some administrative rule changes to. So piggybacking off some efforts that are already underway is usually a way it's going to probably get some legs. This is a standalone item. Probably not going to get too much response from, I mean, that's my guess, from DLCD because they've got a whole backlog of rulemaking changes that they've got. And I just don't know if they have any for Goal 15 at this point or not. We can certainly put together something that, you know, would request that of them, provide that to DLCD, and hope that there is some efforts that are, you know, in the pipeline. But they probably aren't going to take it as a standalone issue. They usually try to package and bundle, just like we do with some of the code amendments. They try to bundle those and make them kind of...
No, I understand that, but I think it should be brought to their attention. And if it's
Yeah.
only a page or so, I mean, we just went through 1,000.
Right.
So I think it's not that it's that much more work.
Do you know, does DLCD receive items like this, asking for clarification or suggesting?
Oh, yeah.
They do.
Do they
Yeah.
keep a housekeeping list?
I don't know. They're organized so that they'll have someone on staff who is the go-to person on Goal 15. I don't know who that is. And, you know, it depends on, honestly, how that individual organizes their desk. But, you know, I regularly make recommendations.
Well, Steve and Emily, let me ask you, if there is consensus among the commission members, would you be willing to draft something addressing John's concerns and let us take a look at it? And would that come from the chair or from the planning director?
Probably wouldn't hurt to be maybe planning director and so we can certainly draft something.
Is there a consensus among the planning commission? Would you like them to spend time on that? Anybody opposed? Yeah, if you would, please.
Yeah,
Pass
I mean,
it out
I'll
to
tell
us
you,
by 5
I'm sitting
today.
here kind of half listening because I know that when counselors make special requests like this, the city attorney, Glenn Klein, is very, there's a process for deciding whether or not staff can spend our time this way.
Okay.
So I do appreciate that you're asking everyone, and I think it makes sense. It's not a big deal. But if this kind of thing kept coming up, I would have to figure out protocol.
Okay.
Well, this is the first time in 10
It
years.
is, so I'm on the webcast being
Keep it at that
quiet.
Would you like us to take an exception in a plan amendment proposal? Steve?
Just having worked in state government, I would suggest that you jointly address this to the Bureau of Water Resources and the Department of Land Use.
Yeah,
DLC, because I think you're more likely to get a cooperative arrangement between the two agencies where...
Perhaps also Division of State Lands, or whatever.
I mean, I would appreciate, I think, more input on that, because I have a feeling that the DLCD rep who does Goal 15 is probably going to be less keyed into the importance of this issue than
Right.
probably someone in Water Resources.
Right. So I just think that, and they deal with these kinds of issues all the time, not this specific, you know, related to the greenway, but water-related issues like this all the time. And so they would probably be more likely to...
Rocket.
Try to walk through a clarification in the code that they think will make their job easier in the
Good.
future.
Okay. Well, if you would, see something by 5 today. Hey, we've got
1:30.
40.
We got time.
They've
Okay.
got free time right now. We can work it up right now.
Well, let's go on to agenda item 3, items from commission and staff. Steve, I saw Carolyn here. Is she still here? Is there anything from the staff?
Nothing from me. I don't know if Carolyn, nope.
First item from the commission, we talked more about having a planning commission retreat, and I've asked Bill to work with Carolyn to establish a time and a location and put together an agenda.
And I've agreed.
And he's agreed. And I know that Bill will be soliciting input from each of us as to what agenda items we ought to consider for that. Are there any other members of the Planning Commission who would like to work with Bill on that retreat planning committee? Okay. Well, you're a popular guy, Bill.
I guess.
Oh, Jeff will. Okay.
Okay.
We've got to, keep it down to 3 or less. But okay,
Yeah.
so Jeff and Bill.
I'll volunteer.
Okay, super.
John Belcher has expressed an interest.
Oh, did he?
as well.
Okay.
He was the one who raised it first. So I-
That's right. So
Okay.
John and Jeff and Bill, Steve, that okay? Good. Okay. So guys, get the word out to us, solicit input, and see what we have. Okay.
Right.
Any other items from commission?
On that point, there are special laws about retreats that loosen up some of the normal public meeting stuff. So maybe if you have questions about that, let me know.
Okay.
Did I already tell you?
Yep.
No.
I'm looking at Carolyn. All right.
Other items from the commission?
Just a question, what's the topic for the executive meeting this Friday?
Steve?
It's based on a state statute that I can't name right now, but it's in the notice, that allows me to come talk to you about written legal advice. I'll bring the written legal advice, and we will talk about what I've written and nothing but what I've written. It is not about a particular development application. And so, find out when you get there. Do you have any problem with me? No, I will tell you, it's actually a legal training on the needed housing laws.
Which is what it was originally titled earlier on, and
Taken off.
then it was taken off.
And, I want to just provide some basic understanding of the laws, what they say, how they work, and what the courts have said about them to help you as you go into another development season. We have some new members, and I think I've done that training possibly with you guys in the past.
Not that focused.
All right. I've talked to the APA about it a few times, and it always seems to be a matter of interest, so.
Oh, yeah. Okay. Steve?
I have a question, because I will not be here, and that's a closed meeting, as I recall, won't be webcast, right?
Right.
That's right,
And
but,
I will not be here now either.
Okay. You
yeah,
might be able to do some quick circle back with the two members.
Well,
A mini session?
I mean, the session, or maybe you could record it and we could view it at a later date at your place so it would be secure or something like that.
well, or, yeah, just an audio recording even.
Yeah, an
We're
audio
going to have
recording.
that.
Okay,
Yeah.
yeah.
Okay.
We used to do a lot more of that.
So, looking ahead, the final decision on Good Pasture, Thursday, November 15th, 11:30, either here or in the slow room, so pay attention to your agendas. Prior to that, though, on Wednesday, November 14th, the day before that, in the evening at 6 o'clock, a public hearing on Deerbrook, and that will be at Harris Hall. So Harris Hall on the 14th, and then backing up even closer, this Friday, executive session in the Saul Room, 3rd floor in the atrium, at noon.
Yes.
Okay? Rick?
Have our public hearings been changed to Wednesday nights permanently?
No, this was a
The
conflict.
last one was a Wednesday night also, if I remember.
Council can't meet Monday because it's a holiday, so they have Tuesday, and that's the only meeting place available right now is Harris Hall, so they have it Tuesday. You would have been there if they weren't meeting. Conflict here, too, that we couldn't bump.
Second band or something.
Apparently not.
I think if you speak in prose.
Just, I wanted to note that I rearranged my schedule, so I'll be here for the Deerbrook PU hearing on next Wednesday.
Good. Good.
But I won't be here for Friday.
Okay.
Sorry.
Yeah.
Anything else for the good of the order? Thank you all for a good meeting. We're adjourned.